We seem to be cornering the market on questions on this road here. My name's King Alexander. I'm E. King Alexander. I'm not the F. King Alexander who is somehow affiliated with another school down there where I graduated in 1987. I am one of two life without parole supervising attorneys at the County Public Defender's Office. And I started there after Hurricane Rita, which was very devastating for us. After 15 years of doing insurance litigation, I worked for a federal judge, and then I did all that. And then I felt moved to return to public service and became a felony defender in one division for 5 years. And when they created these life without parole petitions, I was offered one. I've never been happier in the practice of law, I must say, than since I've been doing indigent defense. But as soon as I became aware of this issue, of course I became very acutely aware in the very first jury trial I tried, which was an aggravated rape trial, the 10-2 verdict. The very first one I did was 10-2, and it was an ag rape, and it was a white man who the victim had bit off this much of his tongue, and so they had it on the evidence table and so on. But I thought it was very unfair because that would not have been an aggravated, that wouldn't have been a life without parole mandatory in any other state. And in 11 years of doing this now, the state has never achieved a fully unanimous verdict against me in a sex case. Never. I mean, when I say fully unanimous, sometimes there's more than one count and sometimes there's more than one victim, but they've never got 12-0 for every victim or every count in the same trial. Now, unlike Gary, who's they've never got a fully unanimous against him in Orleans or in a murder case, a second-degree murder case. For capital first-degree murder, it's still 12. And I think that the legislature, even back in 1879 and 1898, they knew that if they executed people on non-unanimous verdicts, that the U.S. Supreme Court would get involved. And we've heard in some of the discussion so far, the U.S. Supreme Court gets involved when Mr. Duncan was speaking, that because capital is on the table, they're much more likely to grant cert. So Louisiana is kind of skulking back and able to get away with this because it doesn't apply to capital cases. But I have a particular question for the professors and actually all three of you, because you've done a lot of litigation, Mr. Duncan as well, on these issues. Preserving the issue. You're probably familiar with Louisiana Supreme Court, Louisiana Supreme Court case State versus Hatton, which is kind of the latest statement about how to preserve a constitutional issue. Professor Snowden mentioned a motion in limine. The motion in limine can come up actually during the trial, but I'm concerned Louisiana Supreme Court may say that if we wait until we've begun the trial, then State versus Hatton, you haven't preserved the issue. But I've had them go even worse than that. Now I have one judge who says the issue is premature until a non-unanimous verdict has been returned, because there's no reason to decide a constitutional issue until you have the set of facts that would give rise to it, and they're actually not supposed to reach constitutional issues unless they have to. I think there's some merit to that, but I see them play it both ways, and that very judge will say you can never file something at the right time. Anytime I file something that might help my client, it is either premature or I have waived it. You know, if I file it soon, it's premature. If I file it later, like during the trial, then I waived it. And so I guess my question for you, and one more anecdote before I get the answers. And this was, I think, reported this year. It might have been State versus Sims. It was one of the trials I did that was not fully unanimous in the sex case. I do this in every jury trial. All my cases are 12-person because they either carry life without parole, or I get some from the other lawyers give me that carry up to 99 years. The 25 to 99, at least 25 without benefit, those kinds of victim under 13 cases. I file the motion challenging the constitutionality of non-unanimous verdict, and I raise the right to trial by jury. I cite McDonald versus City of Chicago and all the other good cases for that. And I raise not only the 6th Amendment via the 14th, I raised the equal protection argument, which our Louisiana, all of our elected judge courts avoided as much as they can, and so far they're very successful avoiding it. I raised it, and I raised it again because when you ask for jury, special jury instructions, you have to do, the code says you have to do that in writing. It doesn't say when you have to do it, but you have to do it right. So I do it in writing. And then I thought, well, if I don't make contemporaneous objection, that could be another thing. And sometimes if you get hustled to trial without having filed all your motions, at least you can make that contemporary objection, because it's very important to have raised this issue on the record, because the difference between the guy who gets out someday when the U.S. Supreme Court rules could be whether or not his lawyer made that record. And the one might have identical facts in every other respect. If his lawyer didn't preserve that issue, then he's not going home and the other guy is. But I raise with, at the time, you know, we've had the charge conference, and I tell the judge and the prosecutor, I'm going to object to the non-unanimous instruction, you know, which I've already litigated pre-trial. And I do. The Third Circuit in one of these cases said, well, the trial attorney in his contemporaneous objection talked about the right to trial by jury and said that it should be unanimous in the federal way because of the incorporation doctrine. But he didn't say anything about equal protection, so he waived that. He waived that argument. Now, I litigated it completely. It's in the four corners, all the Hatton rule, in the pretrial motion, briefed, particularized, and actually litigated. It served on the Attorney General and actually litigated. And then they'll hang their hat on me having an incomplete contemporaneous objection where I object on basis of right to trial by jury and incorporation, but don't say the magic word, the Simon Says words, equal protection of the laws. So my question for you is, what do you recommend on how best to make a record that will squarely present the issue of the unconstitutionality of the non-unanimous verdict?
If I was a lawyer, one day I will be, I would file individual motions prior to trial, motion objections, under the 6th Amendment, the 14th Amendment, the equal protection, and on separate motions, make sure they get stamped. And prior to trial, I would do it. And then after trial, I would do it. And the reason why I would continue to do it, because that's what the courts seem to be looking for, is the derail the case. They're looking for ways to say this issue was not properly presented. And in the case of Hampton, his lawyers presented the equal protection, but they said, well, you didn't ask for an evidentiary hearing.
They must say, you didn't say Mother May I, or you didn't say Simon Says.
I agree. Commenting on this.
Just a brief comment. I'm Ed Tartley. I'm an attorney in Alexandria. Practiced law 36 years. I served as district attorney in Grant Parish from 1991 to 1997. Frankly, I would like to say that I don't think the Louisiana Supreme Court will ever grant relief on this issue. I don't think it'll ever happen. What I think is going to happen is simply this. The people have to change this. This is an issue of federalism. What that means is that the citizens get to choose. The citizens get to decide this. We, the people, individual people, we can change this. Not the courts. I think we've waited too long for the judges to do anything. They're not going to do it. So it's time for the people to take care of this. And the reason it will be taken care of is because everybody has been denied the full protection of the 6th Amendment. Everybody, black, white, red, yellow, everybody has been denied. All of us have suffered as a result of this. This is an injustice to everyone, and it needs to be changed now, because unanimity is at the heart of the protection of the right to trial by jury. All the way from the Magna Carta, for 500 years, unanimity has been the key. That is the most significant part of it. Not the size of the jury, unanimity. You can have 6 people on the jury, it's got to be unanimous.
the Supreme Court said that. 8, 9, 10, whatever, 15. It's got to be unanimous. It's not the size of the jury, it's unanimity that matters. And that is what we need to talk about. And we need to talk about the fact that we have all been denied the full protection of the right to trial by jury. 48 states, 330 million people are protected by this right, but not the 4 million people in Louisiana. You know who needs to change this? The people of Louisiana. Stop waiting on the judges, stop waiting on the lawyers, and start doing something yourself. It's time for the people to take care of this. And you know how we do that? We have legislators, we have senators, we have representatives, we have mayors, we have DAs, we have all kinds of people that don't have any idea about this. They don't have any knowledge of this. In fact, most lawyers don't know anything about this. You talk to a guy that does real estate, or a guy that does personal injury, he didn't know about this. He forgot about it. Let me tell you something. I didn't realize myself the odious and shameful background of this law until I read the book by Thomas Allen. And when I read that book, I thought to myself, isn't it a shame that all these years have passed and no one has risen up to right this great wrong that has been imposed on our state? So I'm telling you right now, the lawyers can keep litigating, we can keep filing briefs, and we need to keep doing all that. This is not going to change until the people of this state understand that they have been deprived of the full protection of the Fifth Amendment, of the Sixth Amendment. And all of us are affected, everybody. Everybody's affected by this. You realize you can go to Texas and you have full protection. You can go to Mississippi, you have full protection. You can go to Arkansas, you have full protection, but not in Louisiana. It's a shame, it's a disgrace. And let me tell you something. I'm ashamed of this. I really am. I'm ashamed of this. I've been practicing law 36 years, and I've only realized this in the last year. I'm ashamed of our profession, that our profession hasn't risen up and done something about this. Last year, I introduced a resolution in the House of Delegates of the Louisiana Bar Association to put the Bar Association on record that we need to ask the legislature to the Constitution to restore the right to unanimous jury verdicts in this state. We had it for 80 years. Now we haven't had it for 136 years. It's time to restore it to Louisiana. This is about restoration. It's time to restore what we had and what's been taken from us. Okay? The Bar Association is now on record. We need to keep going. So I'm just telling you right now, we've got a great thing to do here. We can do it.
So much. We have a question from this young lady back here waiting patiently. Thank you so much for being.
My name is Fatima Man. I'm a second year here, so I don't have any anecdotes about going in front of the court system yet. So I do have a question. Based off of everyone's comments about litigation and going to legislature, what do you think is a good plan in terms of utilizing like community organizing, along with people to write adequate policy, along with research that indicates that there is an issue with this jury selection. And then also utilizing, I guess, data that indicates the race of the attorney plays a part in how jurors actually respond as well. Has there been a conglomerate effort from just all of these different, segues of people? So you have people lobbying, and then you have individuals creating test cases, right? So like back in the day, we all know the story, when they used to actually have test cases, right? People would say this is the perfect case to bring up, apart in front of the Supreme Court in order to establish this new thing. So has that been a strategy that people have been taking to be able to say, let's go to war from all aspects? We're not just going to go through the front door, but we're going to go through the back, the side, and the windows as well.
As it relates to the community organizing effort, I personally think that's the approach we need to be taking. As the gentleman indicated, we need to stop waiting on the courts and the legislators to make action. We as a community need to tap into our power. And so with the Juror Project, what we do is we give presentations at churches, neighborhood associations, high schools, college, law schools, to really try to empower folks to understand this is a community-led effort. That's where I think the push needs to be happening, is on the front end, to do our part to diversify the juries, because we do know more diversity equals more fairness. And so that's kind of one way that the Juror Project is trying to tap into the community to empower the community in that way, as well as partnering with other community-based organizations. Your comment about the impact of the cross-racial representation, if it's a black defendant and a white lawyer, there is tremendous study by Perception Institute. If you go to perception.org, they specifically talk about a concept that's called racial anxiety. I think one thing we all know about is implicit biases, and the next thing we're all going to learn about is racial anxiety. And it specifically targets and addresses the anxiety that can be created in cross-racial interactions. So a black person interacting with a white person may be very cognizant of the way that they're talking, the way that they're standing, their appearance, things of that nature, to be aware that they don't want to be perceived as being threatening in any type of way. You then look at the opposite, the other side of the conversation, where a white person interacting with a black person is going to be very aware and cognizant of the way they interact with the black person for fear of not coming off as being racist, right? And so when we take those ideas, those implicit biases and that racial anxiety, and we apply it to representation between opposite race, lawyer, and client, that's important to be aware of, right? It's very important for me to know how I need to be interacting with my client if he's not the same racial background as myself. But even also where we need to figure out how that plays a role in the deliberation room, right? So there's a Supreme Court case, Peña Hernandez versus Colorado, specifically where the Supreme Court is deciding whether or not the commentary that took place in the jury deliberation room can be basis for a new trial. And so there was a juror who was a former member of law enforcement who made a comment along the lines of, I knew that this person was guilty because he was Mexican. And so there's this idea of the sequester rule where basically whatever happens in the deliberation room, you know, it's like Vegas, what happens there stays there. But now they're trying to raise the issue of, you know, that there was some type of racial bias or, you know, discriminatory practices that took place in the actual deliberation room, and that can be grounds for a new trial and an issue that can actually be raised in the Supreme Court. So we will be seeing that as well. Can I answer your questions?
And I'd like to add one quick observation about the value of these collaborations, because I'm just ending this 6-year journey of doing this with Angola 3, and I think you all remember that ended on a good note. But Angola 3 was a beautiful illustration of what it is that I think we have begun tonight, because there were lawyers who were committed to making sure they preserved the claims in court. And then there was an advocacy team that was committed to making sure people understood the role they had to play in government. And so the reason the sign-in sheets are here tonight is because we are asking for your joint hands. We don't want just lawyers doing this work anymore. We want the public to become engaged. That is what civics was about. That's the whole concept of government. And we're asking tonight for you to really do some self-inventory and figure out what is your skill set. And if it's Twitter, tweet until your hands hurt. If it is writing, get some articles out. If it is song and arts, do plays, music, educate people so that people feel called to act. And one of the fascinating things about the work that I just finished with Angola 3 is I remember approaching this so nervously, thinking, how do I convince people to care about a prisoner in solitary confinement? But what I realized quickly is that people don't even understand that the justice system has been a tool for politicians to win elections. And when people understood that justice really has been a game, and that this is really not about public safety, but that we have violated people's rights under the shield of safety, when people understand the layers of complexity involved in justice and they realize how often we get it wrong, they feel very empowered and they will act. And so Fatima, what we're asking you to do is organize your troops. We're asking everybody in the room to not have this be a Sunday service where you heard the minister, but hear the minister and feel called to act. So leave here and do something. Whatever your skill set is, we need it. This is not going to happen overnight, but I can guarantee you this. No change takes place when you sit back and wait for somebody else to do it. You have to own your piece of this, and this is affecting all of us. Okay.
We have a question from the back of the room.
Good evening. Other than what seems to be the obvious undercurrent of racism, what seems to be the Supreme Court's reluctance to address this 10-2 rule when it seems so obvious? So what I'm asking is, taking racism off the table, is there any other compelling reasons they offer why they refuse to address something that seems pretty straightforward?
I'll give it a shot. And this is based on my 10 years of working in an appellate court. Because I very naively thought when I went to work at an appellate court that meant that people really sat down and they studied legal issues and they tried to figure out what was just and how law and facts weave together. And what I soon learned is that the appellate process is ultimately a sniff test, particularly in criminal cases. You don't get, the Constitution won't even allow it. So if the courts wished to go into this deep level of analysis on these cases on appeal, they're not even allowed to do it. So on an appeal, according to the Louisiana Constitution, if it's a criminal case, they don't revisit facts. They look at law. And in this case, the Supreme Court has set the law in Apodaca in 1972. And so our Supreme Court says we're not able to help you because the Supreme Court has settled this. So that's one piece of it. But the more important piece, I think, is if a Supreme Court in the state of Louisiana should go on record to say that we have violated your Sixth Amendment rights, defendant, that means every other defendant who's convicted under this system implicitly has an acknowledgement that his rights were violated. And so there's this thing of, do we want to open the floodgates of litigation? So if we touch this, do you realize how big this becomes? Do you know how many people have been victims of this system? And all of those people now show up and say, what about my rights that you took from me? So in my opinion, I think that is why, that nobody wants to touch this, because it's a Pandora's box.
One final question here in the front row.
I'm from next door, Albert Samuel. This has been kind of really enlightening to me, and I'm not a lawyer. I'm a professor of political science. Next door. In addition to some of the other comments that were made, I think the gentleman who said that can't wait for the judges to solve it. You know, people need to solve it. And there's a variety of things. People need to be reminded that the justices of the Louisiana Supreme Court are elected. You remember that. And so among the other strategies, this should be a voting issue for citizens. I just want to make that one comment.
So are you suggesting that all of us should show up at the next election rally and sort of disrupt things like the Black Lives Matter? Is that what you're calling for?
Well, I mean, I'm not saying that we shouldn't do that, but I think that this is where people need to be reminded that the justices of the Supreme Court are elected. So we should make the issue of non-unanimous verdict a voting issue. Exactly. Educate the public. This is a voting issue. And if you're not willing to visit that, maybe the citizens need to return you from the bench and back into the play. This would be a voting issue.
They have a race right now in the South.
Yeah, I just, first of all, I want to thank everybody tremendously for being here and for what I think was a really great conversation on, an issue that is more important than most people realize. I want to kind of tie a few threads together, some comments that have been made. First of all, to, Ed Tarpley, boy, you're a tough act to follow, and I can't imagine ever having wanted to litigate against you. But I think it's important to remember when Ed says that the people need to take control of this. This will require a constitutional amendment, folks. This is embodied in the Louisiana Constitution. It's not easy to amend the Louisiana Constitution. It takes, is it a 2/3 vote of each house of the legislature, and then it goes to a popular vote. Okay, so remember, this is a long-haul strategy, and the legislators are going to be afraid to vote for this until they know that their constituents care about it. So the first thing is to talk to everybody you know, just like the professor said, talk, tweet, scream, yell, holler, whatever you're good at. to get people to see that this is a problem, and then they can talk to their legislators, and then the legislators might have a little bit of a backbone to vote, so then it'll come back to the people, and then everybody can vote for it. But that's what it's going to take. If it's not a litigation strategy, then that's the strategy. I don't think there's a third way. If there is, I can't think of what it is. But another issue that nobody's mentioned tonight, because we've had a lot of other things to talk about, is the fact that non-unanimous juries have a very high error rate. And they have led to a lot of false convictions. And for every false conviction, you have two problems. One, you have an innocent person doing time. And two, you have a guilty person not doing it. And this is something that can be made out as a public safety issue. Because when you convict the wrong person, you haven't convicted the right person. And if you want to make sure that we're getting the right people behind bars, then you need to make sure that we're getting the right people behind bars. So that's another talking point. And I think maybe as we proceed further with these conversations here and around the state, that's something that needs to be considered, because it's a way that other people might kind of feel better about it. Oh my God, there's the real perpetrators out there somewhere. Shouldn't be worried so much about that anyway, but as long as people do worry about it, let's, focus it the right way. Thank you.
Thank you, Marjorie.
I'm Ashley Heilprin. I am a board member of the ACLU of Louisiana. I'm also the president-elect of the Greater New Orleans Martinet Foundation, Martinet Society. And I'm a lawyer in New Orleans. A commercial litigator, so I have not had any criminal experience yet, but I definitely was inspired by this panel to have someone mentor me so that I can maybe one day take a pro bono case. But I want to say thank you to all of our sponsors who helped to make this event possible, who helped to get the word out, to fill this room, to our wonderful panelists who came and I think really enlightened us. So we just give everyone a round of applause for that. The next thing is, like Marjorie said, it's really important to stay in the loop. And this is something that we have tried to litigate forever and has not been all that successful. And I think, like she said, it's something that one day, and hopefully one day soon, will come to a vote. And so staying a part of the loop is important. Raising awareness on this issue is important. I am guilty of what this gentleman back here said, and I was clueless. Last December, I had criminal court jury duty in Orleans Parish. Thankfully, Will Snowden is my friend. So I'm sitting there. I did not have a negative attitude towards jury duty because it was December, it was the end of the year. But I was sitting in jury duty and I was listening to voir dire. And I heard the attorneys educating the prospective jurors and saying that they did not need a unanimous jury in order to convict this man of this particular crime. And I did not grow up in the state of Louisiana, did not go to law school here, and that was foreign to me. In my mind, I don't practice criminal law. In my mind, I was thinking like O.J. Simpson, People versus O.J. They didn't give a unanimous jury, he's semi-free. And so I didn't know about that. And I sat there, and thankfully I had Will to ask, and he said, yes, Ashley, this is an issue in Louisiana. And thankfully, this is an issue that the ACLU of Louisiana cares about and is making an issue for our state. So this is the first of a series of events that we're planning around the state. We're planning to build a coalition of many different organizations to work together collaboratively to raise awareness across the state so that then one day we can see change. So what's important and what I'm asking of you is to stay in the loop. Outside, we have a sign-in sheet. If you would, and if you're interested in staying in the loop on this issue, please put down your name and email address. You will get an email probably from me or from Marjorie that will say, thank you for coming to this event. If you want to stay in the loop, you can opt in. And that's a way for us to tell you when we have more events coming up so that you can tell the people in Alexandria, the people in all these other parishes, all across the state to learn about this. And the last thing that I have is just because I'm a young lawyer, it's a little slight plug for our law students that I'm seeing in here. We heard a couple attorneys talk about the exciting and passionate work that they have. And if there are any attorneys who are practicing in the greater Baton Rouge area, y'all would raise your hands. I think I heard a few, I don't know if you guys are over here. But if there are any opportunities for law students to get engaged, and I'm sure y'all would welcome law students who want to do research and help you with your briefs that are going on these particular issues, please reach out to the attorneys, and I'm sure that they could use your help. That's another way that even as a law student before you're a lawyer, that you can use what you're learning and use your free time, the skills that you have in order to help make a difference. So thank you all for attending. I really appreciate it, and everyone drive home safely.